Mr Speaker.
Chris Bishop.
Well, thank you very much, Mr Speaker. I want to thank all members of the House for their, reasonably positive comments in support of the bill. And it's good to have, I think, my second member's bill in the last year. My colleague next to me is me, but it's good to have a member's bill supported unanimously. And certainly at least a first reading. I take the comments from Tracy Martin that they want to have a good look at the bill at Select Committee. I thought it was a strange speech from Gareth Hughes in response to the bill, essentially running the argument that there are much bigger things that Parliament should focus on. And, you know, I've made this point before in this House that not everything we consider in Parliament is a matter of momentous significance to the country. Actually, the business of lawmaking in New Zealand is about changing laws that are sometimes technical, sometimes boring, but really important, and sometimes really important for particular subsets of people. But actually, this bill deals with one of the most fundamental rights in our Constitution, and that is freedom of expression. So yes, it's technical, yes, it's small, and yes, it arises out of a peculiar set of circumstances, but it actually touches in quite a real way upon a fundamental right in the New Zealand Bill of Rights Act and the broader New Zealand Constitution. And what we saw with the case of Into the River was the revealing of a strange anomaly in the law that needs fixing, and this bill sets out to do it. What we had with Into the River was a strange situation where a book that was an award-winning book, children's book, was published and was essentially taken off the shelves and made illegal to possess or to display for 6 weeks because of a strange quirk of the interface between the appeal functions of the Film and Literature Board of Review and the Classification Office. And actually it's incumbent upon Parliament to do something about that, and that's what this bill sets out to do. And the other point I made during my speech, which I think rebuts some of the points that Gareth Hughes and latterly Barry Coates made, is that it's not just one case. Gareth Hughes talked about the Into the River case, and that was the genesis for this bill, and that's the origin of it, because it's the first time an interim restriction order has been imposed on a book. But as I said in my first speech on this bill, interim restriction orders have been applied to films. And actually, generalising slightly, the Green Party should be the most in favour of at least reforming the power of interim restrictions, because it's things like the incredible film festival, which I strongly suspect a lot of Aro Valley Green Party supporters in the Aro Valley go to in Wellington to watch the weird and wacky films that often get brought over. And they're the weird and wacky films that groups like the Society for the Promotion of Community Standards and groups like Family First try and stop being shown in New Zealand. So it's all very well for Gareth Hughes and Barry Coates to say, oh, well, this bill's a waste of time, but actually it deals with a very real concern for their core constituency, which is wealthy urban liberals in Wellington Central, Mr Speaker. And I talked in my first reading speech about the cases of bully and visitor queue, which had interim restriction orders applied to them by the Society, well, by the Film and Literature Board of Review, but were applied for by the Society for the Promotion of Community Standards, and which were basically banned for the period before which the appeal was heard. And of course the film festival happened for a couple of weeks, and by the time the appeal was heard, the film festival was over. So the Society for the Promotion of Community Standards got their way, essentially, by using this law. And I said in my first reading speech that we need to have a look at that. And there are real free speech problems with interim restrictions generally. They can be abused. Actually, the Board of Review very rarely alters the Classification Office decisions in the first place, which makes you wonder why we need this power. And third of all, they interfere unjustifiably, I believe, or at least there's a case to be made, unjustifiably with freedom of expression. New Zealand courts have viewed with distaste the idea of prior restraint on speech, the idea that the courts should, before anything is even allowed into the public domain, should restrain speech from being made. And in this case, we're not just talking about speech even being restrained in an a priori way. We're talking about restraint on speech after it's made. We're talking about a restraint on a publication after it's actually available into the public domain. So we should be even more wary I believe, sir, or society should be even more wary about placing wholesale restrictions on speech through interim restriction orders. So those are the things that the Select Committee is going to examine. But the bill deals with a specific set of circumstances arising out of the Into the River case. It was wrong that Into the River was not available for 6 weeks because of the misuse of the interim restriction power. I commend this bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye.